attorneys will do their closing arguments, and then I will read you the instructions. Mr. Kuzmin, you may proceed.
Thank you. Good morning. Fortunately, this is the last day we'll have to deal with it. Thankfully, we'll have to thank you them for staying here and deliberating and giving us your time. Now is the time for the attorneys to wrap up the case, tell you what they feel about who was at fault, who was not at fault. This is the time you can comment on the evidence. I'm not going to summarize all the evidence because we've had 3 days of listening to it and taking notes. So I'm going to tell you what I think the evidence shows, and also you will later be instructed by the judge as to the law that is applied to the evidence. That's correct. Some of the instructions that will be given to you, I want to comment on. In this case, we are dealing with a business invitee. And the court will instruct you that Christy Klein was a business invitee, and as such, she is entitled to serve that strapped and band bill in the premises of the safe for. And there's no doubt, in fact, I can't stick with that. You're going to get instructions that, if you listen closely, you're going to make a combination of words. Watch the comment on the word that are going to be used. With regard to the business invitee on the property, an owner of the property is liable for injury caused to an invitee by the property's condition only if the owner he started bringing 41 subsections. Those you have to listen to real clearly because they are in the alternative. Knew or should have known. One, knew that the condition existed. They're only liable if they knew that the condition existed and realized that it created an unreasonable danger to the invitee. And then the alternative, or should have discovered the condition. So, actual knowledge is not necessarily necessary. If the facts show and the evidence shows that they should have known, then they are just irrelevant. Secondly, should have expected that the invitee would not discover or realize the danger of the condition or would fail to protect himself or herself against it. Again, should have expected. The defendant should have expected. And the evidence will have to tell you, in your opinion, whether they did or not. And failed to use reasonable care to protect the invitee against danger. We are maintaining that they did. Failed to exercise reasonable care to protect Christy Klein from the fault she had in the injury. So we think there's kind of negligence here. Negligence is failure to use reasonable care. You're going to get instructed on that, and I don't think the details. Again, you're going to get instruction that says that SBT LLC is responsible for damages to Christy Klein if they knew that a dangerous condition existed and realized that it created an unreasonable invitee, or should have discovered the condition and its danger. Again, in the alternative. Should have expected that the invitee would not discover or realize the danger of the condition, so that fail to protect herself against it, and then fail to use reasonable care to protect the invitee against it. we maintain from the evidence that they do, or if they didn't know, they should have known. First of all, there's no question in this case that there was water on the floor. I think the evidence clearly shows that. The fact that I asked the assistant manager, no question there was water on the floor. No question she fell out. She said no. That's a given. Defendants admit that. The issue primarily is they're saying, well, we didn't know about it. Well, you have to decide whether they should have known about it. Should have known, in this case, is going to revolve around who was there. Now, there was only two witnesses for the defendant. One was the assistant manager and the manager in training. They didn't see it. They came there after the water was all cleaned up and closed it. All they're giving you from the witness stand is what they think other people said. What Peter Paul said. Peter Paul didn't testify. Peter Paul wasn't here to testify. If he was called a military service and can't be here today, there are ways for lawyers to take depositions of people who are not going to be present for the trial. We preserve it so they can read it. And just like we read the videotape deposition of Dr. Pistol, that's not an excuse. Of course, I didn't know that he was not going to be here. I expected it. And they tried to take him. Okay, but they didn't.
Well, hold on. You withdrawing.
Counsel was fully capable of taking discovery for 5.5 years. Comment trial that's anything.
Well, you can bring that out in your closing.
The point is that was never told that he was away. And they knew. Why didn't they take the deposition? They can't bring him into the live program to testify directly. All they gave you is what the assistant manager said that, he said he didn't see it. Now, who has provided the evidence to you about why they shouldn't see it or should have seen it? We have. Christy Klein, Ken Klein testified that Peter Paul was in the aisle. He needed pizza. Maybe something he wasn't supposed to be doing. He certainly wasn't going to admit it to the manager. He would be reprimanded for it. Why didn't Peter Paul see it? He was in there. He was in there all the time in the aisle. He was in there when Mr. Klein and the children came through, come to the front of the store. He'd been there before. Enjoying pizza. Walked all the way down and walked all the way back. He was still there. Why didn't he say, look, out, there's a dangerous condition on it. Why didn't he do something about it? There's all sorts of questions about what they did or actually what they did not do. If he didn't see it, any water on the floor, should he have? He's there. He's also empowered and expected to clean up any water. All of them are. Doctors, utility clerks, the duty of everybody. Do they have notice? Sure, they have notice. And you're going to find that instructions that we given to you that says that a employee of the store, if he is negligent, then that induces to his employer and that negligent conduct. That is the employer-employee relationship. The evidence is going to be judged by you, and you have to decide who has the greater weight of the evidence. In my opinion, this case boils down to one thing. Notice. No issue of water on the floor. No issue of the dangerous condition. Sourness and absurdity. Did they have notice or should they have notice? And should they have done something? They had notice. They had an employee right there in the aisle. On Sunday, they had over 100 employees allegedly walking up and down aisles and sleeping. Last time the floor was struck somewhere between an hour and a half, according to truck. What happened in the interim? Water got on the floor somehow. Over 100 employees in the store, and they don't find it. It's their store. They know what the floor is like. They know what water looks like on the floor. They needed to warn it. They needed to clean it up before something happened. Richard Klein is not at fault. We're going to get some instructions about comparative negligence on her part of her reward, part of the award for her injuries. Should be reduced by her comparative negligence. There's zero comparative negligence. What did she do wrong? She can't see something, protect herself from it. Water is clear, it's on the color of the tile. And this business about the lights on the floor, the manager said, oh, that's from the flash of the camera. They're in business, people do this every day. Why do they take a camera to flash? It was a digital camera. In this day and age, you can take pictures without flash. It doesn't come out perfectly fine. Did she try to show you what a photograph of that door would be without? That's right. I could have done that. We've done it even after the accident was in the store. She wants you to trust her this second. She wants you to trust that the light from the camera is what the light is on the floor that she's talking about. Light above, certainly are lights in the cabinet. That was the exhibit, defendant C6, I believe, showing the aisle of that. And those documents will go to those exhibits will go to the jury. You look at it very closely. You were walking down that aisle, did you see water on the floor with all that interruption? And in fact, that is clear, camouflage, you can't see it. So how could you be negligent? It boils down to the credibilities of the parties. And who will you believe? Obviously, there is a vast difference between the testimony of Jack and Ben Phillips' witnesses and mine. You as jurors have to resolve it. You have to reach down in your own lives, even with people. We instinctively know when people are lying to us. We instinctively know when something is not right. Those of you who have little children, you know when they're fitting. No one's a fitting when they're false. But you judge the credibility of the witness. Who has better witnesses in this case? The only two witnesses you heard was the fact that the people who were there didn't see it, didn't even know there was water on it, except it's their premises, and their managers and the training managers should have known. They're talking about hearsay. Peter Paul didn't say he saw it. Peter Paul said he did not see it. That's all hearsay. Peter Paul's not hearsay. Whereas Mr. and Mrs. Klein are there, they tell you what they saw firsthand. I don't know why it took so long for the manager and assistant manager to get there, because this fall occurred around 11:30. By the time the manager and the assistant manager got there, somebody got a blade, came to the floor, mopped it up, put out 3 cones, and was gone. It took so long to get there. Nobody was there when they got there. So they really can't be in a position to tell you what they saw or what the condition was at the time that this went down. They expect you to believe what they want you to believe so you don't hold them liable. They are liable. And she is entitled to damages. But you are to just judge them as the witnesses, and that's up to you. When you are deciding who you want to believe, you'll get instructions that will say you should use your own knowledge, experience, common sense gains of day-to-day living. Absolutely. And I think if you apply that, you're going to find this way. Well, something just doesn't add up. They don't present the evidence to you firsthand. You believe what they've heard and what is a good defense case. But who is in a better position to know, who saw, who described the condition, and that is the person's The case will come down to damage. Damages in this case are for a number of things. Further instructor. It will tell you that if you decide by the greater weight of the evidence that SVP LLC is liable to personal fine, then you must decide the amount of money that will fairly compensate it. In deciding the amount of money you award, you may consider, one, the nature and extent of the injuries, and the effect of the injuries on their ability to function as a whole person, which is to enjoy life, the way she has before. Two, whether the injuries are temporary or permanent. She had both temporary and permanent injuries. She had pain immediately upon falling on the floor. She answered a question directly asked about that. She's had pain every day. She has pain here today. She needs to be compensated for that. She has 42.9 years of life expectancy. Dr. Pittsford says that how much more you can do for her. She's reached MMI, which is maximum medical improvement. And I asked him, what's your remedy? What can she do to fix it? Pain medication. You can come back anytime she wants to. But we will have, we've gone as far as we can to repair that. It just isn't responsible. We don't have to talk about doing all kinds of bizarre type of surgery. Nobody wants that. She doesn't want that. And there's no guarantee that that's going to work either. So we are going to ask you to give her medical bill that she incurred up to today. And that amount, and that's an agreed amount. That is $24,090.16. I'll show you that in a minute. I have an opportunity to spend time here, as you know, 30 minutes, and then 15 more minutes, because we spoke a lot of 45 minutes, and I'll come back to you 15 minutes at the end, but I'll introduce you to the fact that there are a number of entries and dollar amounts that we assign to them that we'll give you. To put it on you, inside. Maybe those of you who want to take notes and write them down, that would be a good time to do it, but that's not the period. And she would be entitled to her injuries, temporary and permanent. She would be entitled to the pain and suffering that she has experienced and will experience in the future. No doubt, Dr. Pittsford said that she will have to enter the rest of her life. And the reasonable value of necessary medical care and her life expectancy. I'm going to put the amount to the computer.
Well, wait, let me...
She is entitled to as far as damage is concerned. Started at the very beginning. These are Christian fine damages as they relate to dollars. we stipulated, as I said, the $24,090.16 in medical bills. Future medical bills, we know that she's going to have medical bills. We can't tell how much. So we have to...
Objection, there was no evidence of any future medical bills.
Overruled.
She is going to have medical bills. These are what we suggest. $500 a year for 42.9 years comes to $21,450. The $500 a year, we're talking paid medication, going to doctor, going back to Pittsburgh, Dr. Pitcher, and he suggested she comes back, seeking other medical attention. The cost of medication these days, $500 is probably a very small figure. The figures I'm using here are very, very conservative.
10 minutes, Mr. Kuzma.
Thank you. The pain and suffering, which is a major portion of the case, up to now, from the date of the fall to now, we are figuring 5 years and 6 months, and we multiplied the number of days, and we signed $10 a day for pain and suffering up to now from the date of the fall. Is it worth to us, to any of us, to pay $10 a day to be rid of pain? I dare say it costs a lot more than that. You go to the drugstore and buy pain medication, and you're shocked at what it costs. Anesthesiologists put people under medication to put them out and not feel pain. They charge $2,500. So $5, the amount that we have picked up here, $10 a day is very conservative. And for future pain and suffering, we would become even more conservative. For the 42.9 years, we calculated her future pain and suffering and what it would cost, and what value would be to her of $78,290. She has disability. Dr. Pittsburgh indicated that she had a 10 to 50% permanent disability. How much is that worth in your life? Would you sell your disability or give it away if someone gave you $5 a day?
Objection, Your Honor. It's improper to put the jury in the position of the party.
Overruled.
The same company, very conservative, $5 a day for the disability. And finally, as the instruction on damages will show you, she's entitled to loss of the ability to function as a whole person for her life of 42.9 years. Again, we would understand $5 a day, which is $78,000. And all that total in that bottom line is very important. $302,260.16. Conservative, because I didn't want to overstate. I think it is understated. It's up to you to decide what's fair or reasonable. Since the client filed this claim for loss of services, usually we take a percentage of what Kristen Klein's total injuries are worth, $302,000. Calculation, he has about a 25% value of the loss of services, so we figure 25% of the $302,000 came to $75,565. Now, I'll come back to you on final arguments and respond to anything that the closing counsel says about that. This time, I'll see you later.
Thank you, Your Honor. May it please the court, counsel, Mr. and Mrs. Klein, Alana, and ladies and gentlemen of the jury, good morning again. Good morning. Before I get started here, as I was myself, I want to thank you on behalf of Strachan Van Phil for the time and attention you put into this case. You know, I've noticed as you pay particular attention, a number of you are taking notes. You've been very dedicated, conscientious, and I appreciate it. We've been, Jack's been a member of this community since 1930, when we opened our first store in Griffith. Ernie Stack did, and then later he partnered up with Nick Van Til. And we employ a lot of people that are members of this community too, and that's why this case is so important to us to be decided, by members of the community as well. This case has been important to us from the outset, and I think from the last 3 days you can see why this case had to be tried. And I did my best to move it along about a day longer than I ever estimated. I'm usually pretty spot on with my estimates, so I appreciate you taking all this time out of your day-to-day lives in terms of getting this case decided. I moved it along as best as I could. And again, part of my oath, as an attorney, to represent Strack and Van Til, to me it's an opportunity and a privilege. And actually 99.9+% of attorneys don't even know what the word attorney means. It's a term. It's to speak for another. So that's what I'm doing here. So again, it's a privilege and important responsibility as well. And similar to your oath to well and truly try this case, which the judge has told you. You are the judges of facts, and you will be told. You decide what the facts in this case are, not what you've heard about. The judge is going to tell you what the law is as to the issues in this case. Now, the central issue in this case is a question of fault. Is there any fault? Fancy legal name for it is negligence. Okay, that's the question. If Strack and Van Til is not at fault for this incident, and I submit the evidence clearly establishes Strack is not, no need to go any further. The judge is going to actually give you a verdict form. She's going to clear those. Verdict form A. You're going to go back and deliberate. You're going to get all the exhibits. You're going to get the instructions. And you deliberate. And if you go through your deliberations, you find Strack and Van Til did not cause this accident. Strack and Van Til was not at fault. You go straight to verdict form A. We find in favor of Strack and Van Til and against the plaintiff's and plaintiff's claim. That applies to both plaintiffs because Mr. Klein's claim is a derivative claim. His claim is governed by what happens to Mrs. Klein's claim. There's a second verdict form put in there just because Mr. Klein has a claim there. It's a Midland form. And I don't suggest that it even be necessary. But if you say, okay, you know what, Strack and Van Til is 1% at fault, and plaintiff's 99% at fault, you go to verdict form B. Because then it says percentages. There's only 100% of fault in the world. And that's how you fill that out. And the judge will tell you that if the plaintiff is more than 50% at fault, the verdict says we find in favor of Strack and Van Til and against the plaintiff on the terms of the claim. That's verdict form B. Verdict form C is saying, well, let's give plaintiff some damages, which I submit you never even reach. Now, the judge will tell you the instructions. Fault, negligence, is a failure to use reasonable care. It's reasonable and ordinary care. Same thing we all exercise when we're walking down the street, cutting through the courtroom. I try to avoid this whatchamacallit every time, right? I have to curve around it. That's reasonable care, ordinary care. See the things that you can see. Same thing on the sidewalk. There's height deviations you have to watch out. Walking on a cobblestone street, we're driving down the road. We stand on our side of the line. It's a reasonable man standard, reasonable woman standard. Ordinary care. It doesn't have to be extraordinary, just ordinary care. That's the duty owed by Strack and Van Til. That's the duty owed by Mrs. Klein. A person may be negligent by acting or failing to act if they do something a reasonably careful person would not do in the same situation, or fails to do something a reasonably careful person would do in the same situation. The other thing the judge will tell you is you can't speculate as to liability. It can't be based on conjecture or guess. The plaintiff has the burden of proof in this case. They have to come forward with definitive proof that Strack and Van Til caused this incident. They knew about it, water on the floor, in sufficient time to do something and failed to do anything. You can't guess. Plaintiff has the burden of proof to present that evidence. And just quickly, in response to some of counsel's comments while I'm going through the instructions, he said we took so long to come to the scene. Both clients testified we were there within a couple of minutes. Sure, the utility clerk got there right away and started mopping up because that's his job. Okay, Peter Paul called for a cleanup in the aisle. Utility clerk did what he was supposed to do and showed up. Contrary to what counsel said in closing argument, when our manager showed up, Peter Paul was there. Even the Mrs. Klein testified, yeah, they asked him if he saw it. He said, I didn't see her fall. I saw her when she was down. Okay? She said that. So too did Alana. She said, I can't remember if he said she was sitting or he saw her underneath. Plaintiff's counsel talked about who's in the best position to see this water to avoid it or do anything about it. The clients. They also brought up all this stuff about Peter Paul. And boy, Peter Paul's been kind of put up as being just a lousy employee. What a bad guy. He insists on calling him boy for a period of time. Turns out he's 22, 24. Working at Stratton Van Til, going to school, studying wants to be a pilot in the Air Force. He enlisted in the Air Force. And that's where he's at now, serving his country. So he's not available to testify. So it's a golden opportunity to say, what a terrible person. He was just eating pizza all the time. So number one, he's not doing his job. He's standing there eating pizza. The whole time, remember the plaintiff said it took 5-6 minutes to get down the whole aisle? He's still munching pizza. He's munching pizza when they approach. Evidently he's still eating pizza while they walk the length of the aisle with the little kids. They come back, he's still eating. So when any pizza's left, because they cook a little bit, they put it out in the he just keeps eating pizza. He just stands there. And even Mrs. Klein wants to suggest, he knew that water was there. There's no evidence to that effect. She said, well, I suggest he did. Because all of a sudden he's there, she keeps trying to pull him further down the aisle, which is kind of interesting too. Which I'll come back to in a minute. But the point is, they say he's standing there eating pizza and just watching, and he stands there and watches her fall. Doesn't say, are you okay? Or, if it doesn't come to her assistance, doesn't do anything, he just stands there in shoes. Okay, but the judge will tell you, what's more probably true than not true. That's your instruction. You use your own life experience that you use every day. You don't check your common sense at the door. Does any of that make sense? Number one, he's not working. Number two, he's just standing there all the time, just eating pizza. Number three, he doesn't come to her assistance at all. Do anything. He doesn't call for help. What's more probably true than not true? So, they know he's unavailable, so here comes all these things that come out. Oh, he's trying to look at the dress. Gee whiz, where the hell did that come from? Now, counsel says, hey, Pollock should have taken his deposition. Well, until Monday afternoon, he was never a witness to this incident. He was a post-occurrence witness. Mrs. Klein confirmed that in her deposition, as did Mr. Klein, as did Alana in her testimony. Counsel said he would have hurried up and taken his deposition. Nonsense. He wasn't a witness to the incident, but counsel certainly could have taken his deposition before he went in the Air Force and was serving his country. He waited until he could take Alana's deposition until December 19th. Less than a month ago. Oh, he would have been in a big hurry and got it done. They didn't know. Well, they know he's not going to be here, so it's just a swell opportunity to say bad things about him. Alana said to the contrary, he's a good employee, he's there for a number of years. Would they hire him back? You bet. But because he's not here to respond to these allegations that the plaintiff came up with as a Monday afternoon, first time ever, we never heard anything about pizza. We never heard of him being a witness. And in fact, you remembered in her deposition, as of June, I think it was June, that's the doctor, that doesn't know. June 5, 2012. She's not a witness. In fact, that 14-page statement, that all of a sudden when she testified, I don't know if I reviewed it. She read the whole thing during her deposition. We stopped so she could read it. Like we stopped so she could read it here. And she said, yeah, it's true and accurate. Under penalty of perjury. And God. Right? That's her oath. She says in there, I saw him just as I went down. She doesn't say he saw me. She doesn't say we made eye contact. She doesn't say he was eating pizza. She doesn't say he didn't do anything afterwards. Right? What's more probably true than that? That's markedly inconsistent with what she testified to here Monday and Tuesday morning. So who's here to answer for poor old Peter Paul? The answer is you. By using your own common sense, what's more probably true than not true? Does any of that make sense? Anyway, back to the jury instructions just very, very quickly. There's a more specific definition of the duty that's owed by a property owner. Okay, anybody who owns property, leases property, controls property. That instruction says, an owner of property is liable for an injury caused to an invitee by a condition on the property only if the owner, one, knew the condition existed and realized that it's created an unreasonable danger to an invitee or should have discovered that condition and its danger. Two, so they have to know about it. Have to read the notice. Two, they should have expected that the invitee would not discover or realize the danger of the condition. And three, property owner failed to use reasonable care to protect the invitee against that condition. That's the duty owed by a property owner, a strap and band fill. Now the judge goes on to give another instruction that is goes hand in hand with that. That's the burden of proof. The plaintiff has the burden of proof in this case in terms of coming forward with definitive proof that strap and band fill was at fault. What's more probably true than not true? Which means they have to come forward with affirmative proof of notice, which we'll come back to later. But here's the burden of proof. Again, they have to show that it's the same elements. Knew the condition existed, should have expected that the invitee could not see the condition, and we failed to use reasonable care to protect the invitee from that condition. That's the duty owed. A couple other instructions worth commenting on quickly. Judge will tell you, and I have to mention damage. I have to mention the medical stuff, even though I don't think there's a reason to approve the program issue, but I have to discuss this as part of my obligation. She's not entitled to recover for conditions that are unrelated to the incident of LakeCo. So even if you wanted to talk about whatever happened to her as a result of striking and tilt, you should consider all these other things, pre-existing conditions, this plica syndrome, which we'll get into a little bit as well. Yeah, okay, here's the burden of proof instruction. Strap was the owner of property, we've agreed. She was a customer, we've agreed. And then the plaintiff has to prove Strap knew that the condition existed and realized that it created an unreasonable danger to invitees, or should have discovered the condition and its danger. Two, should have expected that the invitees would not discover or realize the danger. And three, Strap failed to use reasonable care, ordinary care, to protect the invitees against that danger. Again, it's a preponderance of the evidence. New term now is greater weight of the evidence. What's more probably true than not true? Again, common sense, life experience. Especially since you had an opportunity to see the witnesses testify, and you can look at the exhibits that the judge admitted in evidence. Which, by the way, there's been a marked disparity in terms of evidence that was admitted. Typically the plaintiff puts in most of the evidence. Which I even said in opening, because that's always what happens. 98% of the evidence goes into that point. In this case, it's just the opposite. Who put all this in evidence? We did. Anyway, in terms of the, looking at the evidence and also the witnesses, the judge will tell you that credibility is always an issue. You look at take into account the interest or bias of the witness. Counsel said, there's no motivation here for for the plaintiffs to exaggerate anything. Goodness gracious sakes, I forgot how much you just requested in damages. I mean, if we admitted liability, this case would not be anything in the range of $50,000 to $75,000. And he wants, what, $375 or something, $400,000? That's a pretty big motivation. It's an outrageous request under the facts of this case, even if we admitted liability, which we certainly don't. That's interest, bias, or prejudice. Okay? And consider the reasonableness of the witness's testimony. Again, what makes sense? What's more probably true than not true? In deciding whom you believe, use your own knowledge, experience, and common sense gained from day-to-day living. Those are some of the instructions you're going to see. You're going to get some. There's some other ones in there additionally, but I wanted to refer to those first. Now, in terms of the evidence itself, we heard some markedly different testimony starting Monday afternoon and continuing to Tuesday morning from Mrs. Klein. Quite different from what she said at the time of her deposition. Quite different from what she said in her statement, 14-page statement taken the day after the incident. And the other interesting point I thought was of note was counsel said, "Oh, when you gave that statement the day after the incident, you were somehow corralled and limited, and they didn't let you say what you wanted to say. So you could have brought up pizza. You couldn't bring up pizza. You couldn't bring up that Peter Paul was a bad guy." And remember, I read some of it. So the follow-up question was, wow, that's a devastating question. It really limits a person responding. And that's where she goes on and says, I don't know if this guy saw it. Were there any witnesses? I remember looking at him on the way down. I don't know how much of it he saw. Next question. And then when the assistant manager asked him, he said he didn't see it, but he saw me down. Next question. Okay. That's it. So there were no witnesses to the incident itself until Monday afternoon, Tuesday morning. There was no evidence. And to come to the next thing, of course, the plaintiff's testimony. I asked these questions over and over again, of course, from the Mrs. Klein, because she's the most knowledgeable person about what happened to her, what she saw. She's the only witness. We go through 118 pages of deposition testimony. I ask anything else, any other witnesses, anything. Now, tell me all about this spill. It was continuous. Couldn't see any source. Not coming from any of the display cases. There's no containers on the floor, no debris on the floor, nothing that would suggest where it came from. There's no spilled yogurt container, box, or anything. All it is a continuous spill, which, by the way, after her incident, no problem saying. In fact, she said, "I can see all the way running down the aisle. All that way, all this way." I couldn't see it before, which, of course, she says in her initial statement. I couldn't see it because the tile was all wet. Of course, the tile is not all wet. And then here's another thing that came up Monday afternoon and Tuesday morning for the first time ever. The lights. The lights blinded me. The reflection on the tile floor. The reflection off the doors in the frozen fruit section. That all blinded me. I thought it was in the Orson Welles film, Lady from Shanghai, where they walk into the funhouse at the end, there's all these mirrors and nobody can see, which interested me when they go home last night, movie time. So yeah, everybody's disoriented because they can't see because of all these flashing lights. Boy, that never came up till Monday afternoon or Tuesday morning. So she's trying to say this spill was there, Strack should have seen it, but I can't see it because of these lights. Later, the point there, when you look at the photos, which are in here, you're going to get it. You see, you don't see it right down that aisle. You can see it from the camera flash, which was a good point. I didn't realize it. But anyway, the plaintiff says, I can't see it because I'm blinded. Mr. Klein goes along with it. Yeah, but I didn't see it at all. But afterwards, he seems to find too. Standing position, no sweat. Up and down the aisle. No problem seeing it there. Well, again, that goes to the question of the plaintiff's fault in failing to observe. And that's why I had some of these questions that if that stool was there when they started down that aisle, they walked right by it without seeing it. Then Mrs. Klein walked by it, second time, without seeing it. What's the possible source? The other thing she says, she testified to, and of course she testified to in her deposition, appeared to be continuous. I mean, odds are it was something coming from somebody's car. Right? That all stands to reason. That's the only possible source. So I've done the rest of the aisle. You'll see the entire length of the aisle. And then the boys came to clean it up. I never saw the spill before the fall. And here goes the question of notes. Do you know how that spill came to be there? No. Do you know who caused it to be there? No. You know how long it was there before you fell? Minute? Seconds? No, I do not. You know of anybody who reported distracting being fell before you fell? No. Do you have any source from any knowledge from any source that Strack knew about this spill before he fell? No. And then I go on, and I ask her here, and of course I had a deposition. How about the appearance of it? Clean continuous. Any footprints? No. Any car tracks in it? Because of course cars go outside. That's why we have those floors professionally cleaned every night. They bring dirt in all day long. No. No car tracks. No footprints. You go back to what Alana says, what, 25,000 transactions a week at that store? That's the minimum amount of customers that go through that store. Sunday's the busiest day. Well, many people do not shop alone. Some do. Like, my sister, when my folks were elderly, would come take my mom and dad shopping. So there's 3 people, 1 transaction. So you can do your own math in terms of saying, well, if there's 25,000 receipts, you probably have 40,000 people that go through that store per week. And by the way, nobody's complained about the lighting, nobody's complained about glare or the glass doors and frozen foods. And for goodness sakes, we find out from Mr. Kuzman's questions, there was never another incident there. Alana says she's only been involved in one other accident, and that's at her current store. For her years of staffing until Gavin said, this is the only one he knows of. That's a heck of a safety record in terms of how we maintain our stores. And you heard about that, I'm not going to go into all of it, but we put more managers on the floor. We put more employees on the floor than any of our competitors. That's one of the reasons we've hung around since 1930 and competed against some of these big national chains that come in, and these, even multinational chains that come in. We do a better job. We care a little more. We try a little harder. And I think that's one of the reasons why, year in and year out, we're the best in the region. We have the cleanest stores and the best customer service. In any event, that goes to our exercise of reasonable care, ordinary care. Council would say, oh, it's just whatever that sweep log is. They just got one guy that kind of pushes a broom and then leans on it, and that's it. Nonsense. Everybody's out there, on the floor, on a regular basis. That's why I ask about some of these other jobs, so you can see where all these people are. And the point is, Mr. Kuzman says, well, they didn't sweep. They finished the last full store sweep an hour before the incident. Well, heavens to Betsy. If that still was there an hour before the incident, there would have been trash. You can do the math. On a Sunday, how many people walked through that store? Employees, customers, that went down that frozen food aisle. There's all kinds of things in that aisle, and you'll see some of them in the photograph, in terms of what people are shopping for, and you've all shopped. This is not an aisle that's only going to be trafficked, every 4 hours. There's always somebody going down that aisle every few minutes, without question. And especially on a Sunday, which we find out is the busiest day. So the point is, if that store was there, more than a matter of seconds, or a minute, or 2, or it might have swallowed, there would have been something in it.
I'll do 5 minutes.
Thank you, Judge. Time flies. I don't have a lot of time. I want to discuss some of those issues. Mr. Klein confirms everything that Christy Klein said. There's no notice to Shrek and Big Joe. They never knew about this thing before it happened.
Does he get 30 and then...
In fact,
Always get told 45.
Oh, no, he's...
That's what this case was until Monday night.
Counsel, I'm wrong. You got plenty of time.
Oh,
He only went 25.
You thought you were splitting it up.
Oh, that's
I'm
okay.
sorry.
My bad.
all right. Who's got the heart medication? How much more time do I have?
You've got about 20 minutes.
20, wow. Roll it down. Which, by the way, thanks so much for sitting through that doctor's deposition. I know that was not easy. You know, I was scheduled for 2 o'clock on a Friday afternoon. Transfer says we started at 2:48. Started late. The thing went for 2 hours and 18 minutes. It was not easy. And I know I was talking fast to try to get that stuff in. And again, because this is all tough, I know some of you have some medical knowledge, but most of us have never heard this unless we got a family member or something happened to ourselves. But I just wanted to get a medical lesson from the doctor in terms of some of the terminology, and then you can review, you know, the doctor's records, and it makes sense. You know, some of the important terms, and I'm going to, as long as I'm on that topic, I'll discuss the claim of injuries. You know, the big issue, I think I said in opening statement, you're not going to scare me again, are you? But is to, you know, look at some of the, we'll listen to the testimony of the doctor and also look at the medical records. One of the issues with reference to the medical terminology is acute, something that just happened recently. So if I back up while I'm talking and go right into the this thing again, you know, and they run me to the hospital, like I got the judge, you know, as a witness, and they say I fell in Judge Ferris's court, and they got all hurt. Go to the doctor. And if that's the history that I give to the doctor's going to write it down. That's his job in training. And I say this hurts. We'll write that down too. Again, a subjective complaint. What I say, I got a splitting headache right now. You're my doctor. You don't know if I do or not, but you're trying to write it down. Then you go ahead and do your examination, your testing, those kinds of things. History, you're going to write down how it fell in Judge Ferris's court. Now, here's the interesting point. In terms of whatever injury I got, any part of my body, if I you know, choose not to tell the doctor that I've been involved in other incidents where I was injured, where, you know, for example, I fell off a scaffold in the summer of 1976, took the express ride down with a full mortarboard, some 8-inch block, some plank, and a bucket full of water. We all came down together, and I was pushing the mortarboard off, trying to get the block off. I turned around to try so this wouldn't land on me. I, of course, landed on the bucket. Pretty well flattened. There was metal in those days. And things landed on top of me. Now, the doctor would certainly like to know that. That's part of my history. But if I say, well, that's not relevant, the doctor's going to say, well, then, whatever injury Pollock has here was caused by his fall in Judge Ferris's court. So that's why full history is significant to a physician. Now, if I tell that to the doc's going to say, wait a minute, let's talk about that. Where were you taken? What was the treatment? What did it, you know, those kinds of things. Then the doctor's got a full picture and can say, well, Steve, actually, this is more likely related to your you know, triple windy off that scaffold rather than the fall in Judge Ferris's court. Or you aggravated something you hurt that from the fall off the scaffold. That's the importance. The doctor is limited to what the patient tells him. Fisher said she never brought any of the records. I did have her on. Okay. So that's something to know. But acute is recent onset. Chronic is something that develops over time. The doctor went on to testify. Yeah, she had this Plecus syndrome, and you'll see it in the medical chart, which plaintiff did not put in evidence, but I did as a part of the doctor's deposition. The Plecus syndrome, something you're born with, or this lady was born with. Tissues normally absorbed during a developmental stage. If it's not, it can be there. It can be problematic. That's one example of things that she had before this incident that were not had any relation at all to strapping and filling. And the doctor said, yeah, it can be problematic. And in fact, that's one of the things he does when he's in there with the arthroscopic surgery. I'm going to clean it out. Now, I'm here anyway, kind of thing. One-stop shop. Let's get that done. Now, when she first goes for treatment, and she goes several places. I think urgent care, I don't know if there was emergency room in there. Family doctor, it was Davidson. And then she goes to Dr. Tremaine. I know she had some kind of negative thing to say about Dr. Tremaine, but I moved on. But the point is, Dr. Tremaine is an orthopedic physician. He's an MD, medical doctor. And, you know, which requires 4 years of medical school, at least a 3-year residency, probably an internship, and usually a 1-year fellowship. Right? And you got to take classes in college that I avoided. Chemistry, organic chemistry, inorganic chemistry, things like that. You got to be a pretty smart guy to do that stuff, or smart lady to do that, which, by the way, my daughter's a doctor. I like the medicine so much, she got the audacity to become a board-certified internist. So now she knows more than me. But anyhow, Dr. Tremaine, and all the docs you saw up to that point said, say what? And this is what I mentioned opening, the location. It's her patella, it's the front of her. What does she have? Soft tissue. Contusion? Effusion. Contusion is a little marking on the skin or a bruise. Effusion? Swelling. We've all had those at one point or another, whether on the schoolyard or anywhere else. It's on the very front of the knee. That's all anybody says. She has all kinds of tests. She has x-rays. She has MRIs. Nope. That's all you got. Got a soft tissue contusion. She complains to Dr. Tremaine, who again I say is a well-regarded physician. He just says, well, yeah, it has some tendonitis too, which is just a strain of the tendon. And even Dr. Pitchford says, yeah, those are conditions that can resolve over time. Contusion, tendonitis. Common thing. Happens to people a number of times, whether it's the elbow or the knee or anywhere else. Well, the thing about Dr. Tremaine, he wants to treat it conservatively. The best physicians don't go to the sharp implements except as a last resort. Okay? You don't want to cut anybody, even if it's a minimally invasive arthroscopy, unless it's absolutely necessary. And sometimes these kind of injuries take time to resolve. Okay? Tendonitis, the contusion, effusion, could take some months. Well, she didn't like to hear that from Dr. Tremaine. And so that instead of listening to a board-certified orthopedic surgeon, she listens to some assistant somewhere and says, oh, go see Dr. Pitchford. Dr. Pitchford's a nice enough fellow. He's an osteopath. And he runs her through a whole bunch of tests, too. Which, by the way, all the tests at this point say there's nothing wrong with the medial meniscus. And he can run a battery of tests, bone scans, other x-rays, all this stuff. Because then he said, I'm in the rule out phase. I'm trying anything. So he's even looking for metabolic disorders. He does blood because there's certain things that affect the joint. Remember, he goes through all those things and says, nothing. It's clean. And then he ultimately diagnoses her with a medial meniscus. When he goes in there with the scope, little camera and one probe, and a thing he said it's like the end of a paper clip, and the other probe is in there poking the sections, and then he talks about a little softer in the medial meniscus. Okay, she's toward the medial meniscus. In fact, she's toward the posterior of the medial meniscus. Well, that's back down here. It's not the front. And that's why I was asking the doctor questions about what causes tears of the medial meniscus. Can it happen without an accident, without trauma? He says, sure. Sometimes that could be the use of knee quick, repetitive motion kind of thing. Or sometimes they just have it. Remember he was talking about how the cartilage can, it's a degenerative condition. Aging, wear and tear. It's not as pliable as it was when we're 3 years old. And so that happens. So the point is, it's 7 months after the incident of Stratton Van Til when she's first diagnosed with a medial meniscus. And I submit that's because there was no medial meniscus or meniscal tear as a result of anything that happened to Stratton Van Til. And now counsel wants to say, well, that MRI, the first MRI, must have been wrong. The radiologist, who, by the way, is an MD, a physician, and I think they have a 4-year residency, and he just missed it. So that first MRI is hollow. Second MRI taken after the surgery says that. Here's the, there's a torn medial meniscus in there. And that was correct. Interestingly, same radiologist as well. So it wasn't there, and then it is. It obviously happened sometime later. Some of these other conditions the doctor talked about, she has some bursitis. I go, what's that, doctor? It's a chronic condition. Just happens. And he said tendonitis can be a chronic condition too. So the only thing, and he mentioned some other things she might have. Remember, he's looking for off a fat pad and all these other things. He didn't find any of that stuff in there. So the only thing he said, well, she had medial meniscus from Stratton Van Til, and that's when he tried to repair the first surgery, which somewhat failed. So he went back the second time and fixed it. And then when she comes back in 2014, He checks it again. I go, yep, well, that appears good. So if she's having any problems now, it can't be because of me in this case, it's due to something else. His work product was good. So that's why I was asking all those questions, and I know I was going on my own minute, but that's the point. The doctor has to say, within reasonable degree of medical and surgical certainty, that this there's a condition related to the fall extract. The only thing he identifies was medium meniscus. And again, that's based upon the history given. Interestingly, the plaintiff said, well, yeah, I was in these other 4 car accidents, but it wasn't, I don't think it was wrong. You can't, it's for the doctor to decide what's wrong. And I forgot what was happening here. I was asking her something else, and she was telling me something that wasn't legally relevant. Well, it's up to the judge to decide what's legally relevant, which leads me to another interesting point. Now, she testified, and she told us in her deposition back in June 5 of 2012, I finally got rounded to, where I went to Northwestern for a 3rd or 4th opinion at that point, and Dr. Bowen says, stop the surgeries. It's not your medial meniscus. It's the way you move. Go see Ellen Casey, a physiatrist at the Rehabilitation Institute of Chicago. She goes. And by the way, just one visit to Bowen. No big diagnostic testing. He just does an examination. So here's your problem. Sends her over to Ellen Casey. One visit says, absolutely. It's not only in counsel's sake trying to say it's just her leg, the way her leg moves. Both Bowen and Casey said, no, it's the way your whole body moves. And that's why she was sent to Casey, because Bowen said Casey deals a lot with how women move. Women move a little different than men, which men notice. But so she specializes in women. And it's a particular type of therapy. She goes to see this guy, Darren Earnshaw, in Hobart. It's like a miracle worker. Does the therapy, little hands-on treatment. Nothing, not banging anything with a hammer. And as she told us on June 5, 2012, pain-free. Problem solved. One could only wish that she would have been referred, perhaps, to Mr. Earnshaw before she elected to go through some of these surgeries. Problem solved. So as of June 5, 2012, pain-free. Of course, the trials in the first month of January 2015, daily pain. Everything hurts. My life's destroyed. Medial meniscus, tracking that until. And by the way, the Dr. Fisher said that's a very common condition. And again, even without accident. I see it all the time. I think he used to say he did 3 or 4 of these surgeries a month on medial meniscus, and then he said, well, 30 to 40 a year. I'll down my estimate, but very common. It happens to all people, all kinds of things. Sometimes no rhyme or reason why. And again, we're all generally familiar with that because we see these injuries at any kind of sports fan. You can't find pick your favorite sports teams. You're going to find half a dozen guys on each team with the same thing. And they're not playing ball or skating, shooting hoops. So you consider that in terms of the plainest description of her problems. Now the other interesting thing, and I'm not going to go through it because I probably am getting low on time.
6 minutes.
She gets this complete relief from Mr. Earnshaw. But then she goes back to Dr. Pitchford after 3.5 years. Said, well, why don't you go back there? Of course, the trial's coming up. Here he is. He can testify. He's local. I suspect his fee for testifying is less than Dr. Casey or Dr. Bowen. Why else would you go back to Dr. Pitchford? Which, by the way, that's what he goes through and says, hey, that MRI is fine. And when he released her from his care back in January 2011. The patient returned as needed. She didn't go back. He released her from her care again last year as needed. He doesn't recommend any future medical treatment. He didn't put any restrictions on the activities. Do anything you want, recreational, home, work. As much as whatever you tolerate, go ahead and do it. You're not limited at any capacity. You have she has no limbs, she has nothing. That's what Dr. Fisher says. Well, my point is, if she was in this daily pain that she's claiming through the trial, well, where should she go? In her nurse shop, right? But hands-on, almost like a healing. How he does. I expect a halo. I mean, my gosh, what a result! What makes sense? What's more probably true than not true? If she really wanted to, she was really suffering pain, need a path to doctor herself. Well, they don't have to prescribe it. Any doctor can, like, that's what they carry in their pocket. They're in her shop. There you go. Her family doctor. So, what makes sense? One of the things, and I didn't say, Dr. Well, she had her sides, I didn't mention it. Dr. Fisher said. One of the things I think is also worthy of note, and again, I don't have time to go through all of this stuff. You'll see in the medical charts, I first flag these things, the MRIs and stuff, but you'll get a copy that was submitted at the time of the doctor's deposition. There was an exhibit tendered during the doctor's deposition, and the plaintiffs were there, that wasn't admitted into evidence, which you probably heard. I said I have to reserve objection because I don't know what it was, what it's based on. In order for things to be introduced into evidence, and this is historical, the rules of evidence go back thousands of years, and they're interesting to me because they're based on human experience. But nothing should go into evidence unless there's a substantial guarantee of trustworthiness. So that's why I reserved objection. And that's why you didn't see that exhibit, and why the video was shut down for a period of time. We find out the exhibit was prepared by Mrs. Klein herself, which is something I've never seen in terms of like my involvement as a lawyer or seeing other cases on the other side, kind of a tail wagging the dog. Somebody hires me to be their lawyer, I'm driving the car. Okay? But she prepares that exhibit, which was not allowed in evidence. And I don't read anything in evidence if it's at least reliable. Like I said, I read the bills. You got a bill from the hospital. There's a bill from the hospital. I'll stipulate to that to move the trial. But that can go in evidence. There was another exhibit counsel tried to use, which I hadn't seen, by the way, before trial, which I don't know what it was. What was this? Again, something else prepared by Mrs. Klein.
I'm going to object. This is not any evidence, the argument. This is something that happened during the course of the deposition.
No, there was a trial.
The jury hadn't heard
Overruled. You can bring it out in your closing.
So I hadn't seen that. We look at that, so that's not an evidence either. Again, so it's something I've never seen. Is 34 years as a lawyer, a couple of years as a law clerk, working in firms while I went to law school. Where the tail's wagging the dog. Very interesting. You'll see at the doctor's deposition, Dr. Pitchford, if you remember, he looked to his right. And that's another weird thing. He didn't have his chart. What the heck's going on? I remember he started stumbling along, and I said, would you like your chart? And your counsel, I've got a copy. It's on my only copy. He says, no, I'll direct him to certain dates. Well, what was he reading off of? Because I was curious. I waited for the whole 2 hours and 18 minutes because I never did see it that day. But I just looked into evidence. It's a cheat sheet prepared by the plaintiff. The poor man is trying to testify off these notes without his chart. That's why I can't get very far. But I looked into evidence because I was curious as to what it was. And that's the note she said, I don't know how we got it. Well, of course we know how we got it. That's why the deposition started 48 minutes late. The meeting prior to the deposition. In terms of trying to explain what the testimony should be. That's why I gave the doctor's chart. Then he can at least talk about what happened. The other point I was going to make, because I'm probably about 3 minutes or 2.5.
Right there.
Okay. Thank you, Judge. Notice how this, how the plaintiff's version of how this incident happened has changed. Okay? Now, I think when I was asking her questions, and this was more a tagging for Peter Paul, he's 8 feet away from him. Well, that was in the trades this time. About 8 feet. But I landed on it. And again, somebody had a question for Mr. Klein. Why didn't you go? He's right there. Why didn't you go to him? Ask for help. That calls him. Great point. So he's 8 feet away. And they do that because they want to try to bring him closer to it must be closer to the scope. He had to see it, right? This is called speculation. That comes up Monday afternoon, Tuesday morning. And he had moved. He was 8 to 10 feet. And I think they blew right by 12 feet. At the deposition, she said, well, I was 15 feet. I was 15 feet from the end of the aisle, because they put him at the end of the aisle. And at the deposition, he's a post-occurrence witness. Well, in the report taken by our managers that day, falls halfway down the aisle. And she signs that report as true and accurate. You'll see it in evidence. So, I'm Mrs. Klein, you're Peter Paul, halfway down the aisle. So they move them along as time progresses because it's a good exaggeration to try to benefit their case and try to come around to deal with this problem of they had no notice. They had no evidence that Strack did anything wrong. You know, by all accounts, one of the potential sources of this spill.
Time.
Oh, I'm almost, okay, I'll do that again, thank you. I just have to find the one photo, Judge. Of course, it's always the last one, right? It's at the bottom. Nope, it's not there either. You'll find the photos of the cars. Arguably, it was the plan's own car. You know, the little boy could have a second time. Okay? Based on the evidence, what's more probably true than not? I thank you again for the time and attention you've given us in this case. Plaintiff has the burden of proof, so they get to go again. This is the last you'll hear from me. So if he brings up anything that I can't respond to, I'd ask you to do answer for me. So again, on behalf of Strack and Van Til and Alana, thank you very much.
Kuzmin?
Thank you, Your Honor. I only have 15 minutes to respond. And so I can't get every item that he's talked about, but it's a desperate attempt to try to instill some evil or conniving techniques or attempts by Kristen Klein or Whitman to say that she had a legitimate, she didn't have a legitimate injury, she's trying to run for the process. You know, you know, you can judge the truth and veracity, and then there's the far across the road to try to picture her as. This is a desperate attempt to try to grant the things that he hasn't got evidence for. So he is conjuring up all kinds of motives. He's asking you to speculate about things that happened that he can't prove. And the instructions would tell you not to speculate. The pre-existing problems like the FICA, that's something you have in your knee from birth. It's bothering her. She's never had any complaints of her knee hurting before. There's none whatever. He's just saying, well, she should have told him about the incident she happened when she was 3 years old. It's a car accident. She didn't think it was applicable. Nothing happened to her knee. Why should she waste the doctor's time to the fact that she had an accident that went away? Yet he wants you to believe that she had pre-existing conditions and you should give her any money for her disease. Dr. Pittsford says that all of her reasons were a result of his fault. And all these other things that he found were incidental. Removed by her simply because it was an innocent death. The other thing I want to emphasize, and Dale knows, confess to negligence. If something is such a very, very heavy day, did they increase their sweeping schedule for that day? No. They knew that thousands of people are going to be coming through. Did they have more people walking the boards in order to make sure that something would happen with all that extra traffic? No, we didn't have anything like that. It was business as usual for them. That's negligence. That's failing to prevent things that will happen, which they know will happen when you put more people in the store. You put more people in the store, there's more chance of something breaking, coming through their shopping cart. You have shopping carts, so anything that at least will come out. The bottom line is that they did not. They don't take extra precautions, even when they know that it is very busy. And they feel that you should watch what she said. There's nothing to that. She couldn't see it. She saw it afterwards. Tim testified that he was walking, or once they knew that there was water, then you were closer to it. And you get down, then down there, and he's pointing to here, here. That's how you do it. And then when you point to it, you look, he's not just on it. But couldn't see it before. All of these things about allegedly, she did the doctor a cheat sheet. She gave him a timeline of all her treatments. It was a timeline of treatments before and after she saw this. And they gave her a cheat sheet. This is desperate things. It doesn't make sense. And you should take that into consideration as to what is going on. The bottom line here is that there is negligence. They have failed to show that the preventative when they could have. All these medical bills that they agreed to were not applicable to the loss, and why did they agree to? But when you come down to the bottom line, this is the number that I suggest is a very conservative number. I suggest that having written it down before this is when we have to listen to research. This is also, and those estimates were very low. I deliberately made them low so that you would think that we were trying to take advantage or emphasize something. You should increase it. So made it low enough as a floor in order for you to say, well, she's at least entitled to these, at least entitled to that. The only way you are going to prevent striking Van Til from being negligent to other people in the future is to show them by a large verdict that that's not the way to run the business. If you're so outstanding and so far ahead of your competition, why don't you take care of your customers? Why don't you prevent them from being prevented premises? You bring them on your premises, you want to sell them things and bring and get their money, but when you injure them because you're not careful enough to keep the floors clean and prevent them from being hurt, then they say we're not at all. Whose floor was it? Whose layout was it? Whose lighting was it? It's all there. They had complete control of it. They did not. All they want to do is not take. And so we recommend to you, ladies and gentlemen, that now Christy Klein and I ask you to return your knee to what it was before negligence, distracted genital surgery. If you can, give her a good knee, prepare for an great to take that out of that. You can. She's got over 42 years of living. A long time because she's a young lady. She's not her age now. And the only way that we are going to be able to let Frank and Van Til know that we need to be more careful is to let them know with a large verdict that this is what's going to happen if we don't take care of this. And so we thank you for your attention, thank you for your consideration. So thank you for the verdict you bring in for her, and whatever you feel is fair, considering all the evidence, is what her remedy is going to be for the rest of her life. So we ask that awesome for you to go in there and figure out what is fair and not damages. We're confident you can do that when the recognition for you is yours.
All right, thank you, Mr. Guzman. At this time, it becomes my duty to instruct you as to the law that you will apply to the facts and issues in this case. You are the sole trier of the facts, but are bound to apply the laws given to you by the court. When you deliberate your verdict, you will have a copy of the following instructions and all exhibits admitted into evidence for your review. Did you give them the instructions? Do we have the copies?
Yes.
All right, ladies and gentlemen. Reasonable care means being careful and using good judgment and common sense. This case must be considered and decided by you as an action between equals under the law. Individuals and groups of people, such as businesses or governmental entities, stand before the court and before the jury with equal rights and equal obligations. They are entitled to the same fair trial and are to be given justice, equal justice. Therefore, you should not allow sympathy or prejudice for or against any party to influence you or control your verdict in any way. Your verdict must be based on the evidence and on the instructions of the court. You must not consider testimony or exhibits that were not admitted into evidence. Consider all of my preliminary and final instructions together. Do not single out any individual sentence, point, or instruction and ignore the others. A finding of negligence may not be based on mere surmise, conjecture, guess, speculation, or probability. A person's conduct is legally responsible for causing an injury if the injury would not have occurred without the conduct and the injury was a natural, probable, and foreseeable result of the conduct. This is called responsible cause. There can be more than one responsible cause for an injury. Negligence is a failure to use reasonable care. A person may be negligent by acting or failing to act. A person is negligent if he or she does something a reasonably careful person would not do in the same situation, or fails to do something a reasonably careful person would do in the same situation. You must decide this case according to the Indiana law of comparative fault. The term fault refers to conduct that makes a person responsible in some degree for injury. The type of fault at issue is negligence. Plaintiff Christie S. Klein, SVT, sued SVT LLC, the defendant. The plaintiff claims that SVT LLC was negligent by not maintaining its property, store, and grocery store and failing to warn them of a substance on the floor. And as a result, plaintiff Christie L. Klein slipped and fell, sustained an injury. The plaintiff must prove their claims by a greater weight of the evidence. SVT denies the plaintiff's claim. SVT LLC is not required to disprove the plaintiff's claim. SVT LLC has claimed certain defenses. SVT LLC claims that it did not cause the wet spot to be placed on the floor prior to the plaintiff Christie L. Klein's incident, and further that no notice of the wet spot was given to SVT LLC prior to plaintiff Christie L. Klein's fall. And finally, if there was any fault in failing to observe the wet spot, the fault should primarily rest with the plaintiff Christie L. Klein as being in the best position to observe and avoid the wet spot before her fall occurred. SVT LLC must prove its defenses by a greater weight of the evidence. An invitee like Christie Klein is a person who a property owner, SVT LLC, invites to enter or remain on his property. Christie Klein was an invitee on the property SVT LLC. An owner of property is liable for injury caused to an invitee by the property's condition only if SVT LLC knew that a dangerous condition existed and realized that it created an unreasonable danger to an invitee, or should have discovered the condition and its danger. 2, should have expected that the invitee would not discover or realize the danger or the condition, or would fail to protect herself against it. And 3, fail to use reasonable care to protect the invitee against the danger. An employer is liable for the negligent act of its employee done within the scope of their employment. A person or a company like SVT LLC conduct is legally responsible for causing an injury if 1, the injury would not have occurred without the conduct, and 2, the injury was a natural, probable, and foreseeable result of the conduct. This is called responsible cause. Negligence is a failure to use reasonable care. A person or business entity like SVT LLC may be negligent by acting or by failing to act. They are negligent if they do something a reasonably careful person or company would not do in the same situation, or fails to do something a reasonably careful company would do in the same situation. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work, as Dr. Pitchford in this case, may express an opinion because of his knowledge, skill, and experience, training, or education. Judge opinion testimony in the same manner that you judge other testimony in deciding how much weight given opinion testimony. You may also take into consideration the witness's skill, experience, knowledge, and familiarity with the facts of the case, the reliability of the information supporting the witness's opinions, and 3, the reasons for the opinions. Party may present testimony by way of written video deposition. A deposition is sworn testimony of a witness taken before trial. The witness is placed under oath and swears to tell the truth, and the lawyer for each party may ask questions. A court reporter is present and records the questions and answers. In this case, the deposition was videotaped and placed into evidence. Evaluate this testimony using the same rules you apply to the testimony of other witnesses. A party may attack the credibility of a witness by showing that the witness made a statement or behaved in a manner inconsistent with the witness's testimony. You may consider the fact that the witness spoke or acted inconsistently with his testimony, in this case, only to determine the weight you will give to that witness's testimony given during this trial. However, a witness testified inconsistently under oath. You may also consider the content of the witness's prior consistent statement as evidence in this case. Base your decision on the evidence and not on guess or speculation. However, damages need not be proven to a mathematical certainty. Plaintiff Christy Klein's fault, if any, is an issue in this case. The plaintiff's fault was a responsible cause of her injuries, then the plaintiff either will receive no compensation or receive only partial compensation for her injuries. Another instruction will tell you how to determine the effect of the plaintiff's fault, if any, upon your verdict. Defendant SVT LLC has a burden of proving by a greater weight of the evidence that the plaintiff was at fault. SVT LLC claims the plaintiff Christy L. Klein's own fault contributed to the injury plaintiff claims to have suffered, and that the plaintiff's fault was the responsible cause of the injury. SVT LLC has the burden of proving by a greater weight of the evidence that plaintiff was at fault. In this case, there are two issues, liability and damages. The fact that the court has instructed you regarding damages does not mean that the court necessarily believes that the plaintiff is entitled to damages. In addition, the fact that a lawyer for a party that has been sued to discuss the subject of damages is not admissible, it's not an admission by them that any party who has been sued was at fault, or that any damages to the plaintiff was caused by any of the parties who have been sued. These instructions regarding damages have been given to you because the subject of damages is an issue in this case. The instructions regarding damages should not be considered by you, only if you determine under the instructions of the court and by the preponderance of the evidence that plaintiff should be awarded damages from any party who has been sued. Timothy Klein has claimed that SVT LLC's action caused him to lose services, society, or companionship of Christy Klein. Timothy Klein is allowed to bring this claim because he is married to Christy Klein. You must not award damages to Timothy Klein if you did not award damages to Christy Klein. To establish a claim, Timothy Klein must prove the following by a greater weight of the evidence. SVT is liable to Christy Klein. 2. Timothy Klein suffered loss of services, society, or companionship of Christy Klein because of the injury to Christy Klein. And 3. SVT LLC's negligence was the responsible cause of his loss. If you decide for a greater weight of evidence that SVT is liable to Timothy Klein, you must then decide the amount of money which will fairly compensate him for the reasonable value of the loss of services, society, companionship of his wife, and any loss that is reasonably certain to occur in the future. You are further instructed that even should you find for the plaintiff unusual liability, you are still permitted to compensate her for speculative damages. You are not permitted, to compensate her for speculative damages. By speculative damage, I mean damages for injuries which, although possible, are nevertheless remote or based on conjecture. If you should find that the defendant is liable to the plaintiff is entitled to recover only such damages as she has proven by a fair preponderance of all the evidence to have directly and proximately resulted from the occurrence in question and not otherwise. Plaintiff Christy Klein was an invitee on the property of the owner, SVT LLC. An owner of property is liable for injury caused by an invitee by the property's condition only if the owner knew that the condition existed and realized that it created unreasonable danger to an invitee, or should have discovered the condition and its danger to, should have expected that the invitee would not realize the danger or the condition, or would fail to protect himself or herself against it. And 3, fail to use reasonable care to protect the invitee against the danger. Christy Klein is not entitled to recover damages for any physical condition that existed before the incident. Christy Klein has asked you to award money damages based on her impairment because of her injuries and her life expectancy. According to standard mortality table, the life expectancy of a female 39 years of age is 42.9 years. This evidence you may consider in determining the amount of money you owe to award, if any. Mortality tables are merely estimates of the life expectancy. They are based on statistical averages of the remaining length of life of all persons in our country of a given age and sex. In considering life expectancy, you may evaluate all facts and circumstances that bear on the life expectancy of plaintiff, including a mortality table and occupation, health history, state of health, and habits. To recover damages from defendant, SVT LLC, plaintiff Christy Klein, must prove each of the following by a greater weight of the evidence. 1. SVT was the owner of the property. 2. Plaintiff was an invitee on the property owned by SVT LLC. Plaintiff was injured as a result of a condition on the property, and SVT knew the condition existed and realized that it created an unreasonable danger to invitees, or should have discovered the condition and the danger, should have expected that invitees would not discover or realize the danger of the condition, or would fail to protect themselves against it. C. Failed to use reasonable care to protect the invitee against the danger. If you decide the greater weight of the evidence that SVT is liable to Christy Klein, and you must describe the amount of money, decide the amount of money that will fairly compensate her. In determining the amount of money you award, you may consider the nature and extent of the injuries and the effect of the injuries on her ability to function as a whole person. Whether the injuries are temporary or permanent. Physical pain and suffering plaintiff has experienced and will experience in the future as a result of her injuries. Reasonable value of necessary medical care, treatment, and services incurred by the plaintiff. The life expectancy of the plaintiff. You alone are the judges of the evidence, including the credibility of witnesses. Credibility means believability. Credible witness is a witness whose testimony you believe. Considering the testimony of any witness, you may take into account his or her ability and opportunity to observe what he or she testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all the evidence you have heard. Assume that each witness has testified truthfully. If you find conflicts in evidence, reconcile those conflicts if you can, based on the assumption that each witness testified truthfully. Do not disregard the testimony of any witness without reason, without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe, and decide what testimony you disbelieve. In deciding what or whom you believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. If you decide that any plaintiff is entitled to recover damages, you must separately decide the amount owed to that plaintiff and list that amount on the verdict form. To return a verdict, all of you must agree to it. In other words, it must be unanimous. Each of you must decide the case for yourself, but only after considering and discussing the evidence with each other. You should try to agree on a verdict if you can do so without compromising your individual judgment. Do not hesitate to re-examine your own views and change your mind if you believe you are wrong, but do not give up your honest belief just because the other jurors may disagree or just to end the deliberations. In arriving at your verdict, you must not consider the tax consequences, if any, of the amount of the money you may award. To decide if Christy Klein is entitled to recover damages from Strack Van Til, and if so, the amount of those damages, a portion of fault of Christy Klein, Strack Van Til, on a percentage basis. Do this as follows. First, if Strack Van Til is not his fault, return your verdict for Strack Van Til and against Christy Klein and Timothy Klein. Use verdict form A. If Strack Van Til is at fault, decide Strack Van Til, percentage of fault, and the percentage of fault, if any, of Christy Klein that caused Christy Klein's injuries. These percentages must total 100%. Do not apportion fault to any person or entity. Next, if Christy Klein's fault is greater than 50%, return your verdict for Strack Van Til and against Christy Klein and Timothy Klein, in this case, and deliberate no further. Use verdict form B. However, if you decide that Christy Klein's fault is 50% or less, then decide the total amount of damages, total amount of Christy Klein's damages, if any. Do not consider fault when you decide this amount. Multiply Christy Klein's total damages by Strack Van Til's percentage of fault. Return your verdict for Christy Klein against Strack Van Til in the amount of the product of that multiplication. Use verdict form C. Also, if you decide that Christy Klein's fault is 50% or less, you must decide damages, if any, you award Timothy Klein. To do this, you must decide the total amount of Christy Klein or Timothy Klein's damages, if any. Do not consider fault when you decide this amount. Multiply Timothy Klein's damages, total damages by Strack Van Til's percentage of fault. Return your verdict for Timothy Klein and against Strack Van Til in the amount of the product of this multiplication. Use verdict form C. We will give you verdict forms to guide you through this process. When you return to the jury room, select one of your members as the presiding jurors to manage deliberation. No one will be allowed to hear the discussions, and no recording will be made of what you say. The bailiff is available to assist you with personal needs, but it cannot answer questions about the case. If you have any questions for me, you must put them in writing and give them to the bailiff, and I will respond as the law permits. You may be able to find answers to your questions by reviewing my written instructions and all the evidence. If at any time you are not all together, or if you are outside the jury room, you must not talk about the case among yourselves or with anyone else. I am giving you forms of possible verdicts. The presiding juror will sign and date the verdict to which you all agree. Do not sign any verdict form for which there is not a unanimous agreement. You have agreed upon a verdict from the bailiff. When the parties are present, the bailiff will bring you back to court, bring all verdict forms signed and unsigned with you at that time. I will read the verdict aloud. Each of you may be asked if it is your verdict. Otherwise, you are under no obligation to discuss your verdict or deliberations with anyone. Juror number 99. Sir, you have been selected as the alternate juror. Your duties are the same as those of the regular juries, except you must not participate in the deliberations or voting of the jury unless I direct you to do so. The presiding juror of the jury shall prevent alternate jurors from deliberating or voting with the jury. Presiding jury shall promptly report any violation of this instruction to me. All right, ladies and gentlemen, members of the jury, in a moment you're going to retire to deliberate your verdict. After you retire to the jury room, of course, as I said in the instruction, your first act is to choose a foreperson. I'm sure you've seen it. We've got a little instructions there on how you go about that procedure. After your deliberations and when you have reached your verdict and properly prepared verdict form, you should complete it, signed by the presiding juror, and return to open court. My bailiffs, you want to stand and be sworn? Mr. Georgie and Mr. Shirelli, you solemnly swear or affirm that you will take the jury to the convenient place of deliberation, that you will not communicate with them yourself with regarding the case, or allow others to do so. Ask them if they have agreed upon a verdict, and they having done so, you will then return them into the open court, so help you God.
I will.
All right, you may not